Recently, there's been a debate raging over the issue of internet privacy. Before focusing on internet privacy, however, we should take a moment to look at what privacy means in general. According to Privacy International, privacy helps us establish boundaries to limit who has access to our bodies, places, and things, as well as communications and other information. The unregulated invasion of American homes by British soldiers before and during the Revolutionary War left a fresh sense of unease within the new nation regarding issues of privacy. This unease is reflected in the drafting of the Bill of Rights with the inclusion of the Fourth Amendment. In the early landmark case Olmstead v. United States, Justice Brandeis equated privacy to personal security. In this case, Brandeis was arguing against the use of warrantless wiretaps, a subject of heated debate once again. However, his definition of privacy holds truth in both questions of government surveillance and third-party use of personal information as a result of social media use. The proliferation of communication technology in more recent times has all but offered the personal lives of individuals up on a silver platter to both the public and private sectors. Over the years, private companies have devised several ways to generate profiles of internet users. A few of the important ways are tracking cookies, search engines, HTML5, social networking sites, and internet service providers. Cookies are used to track web browsing history. They can place a personally identifiable tag in a browser to facilitate web profiling. Cookies facilitate the use of cross-site scripting or other techniques to collect information. When the cautious users start deleting HTTP cookies, the websites start using zombie cookies, which are created after a cookie is deleted. A search engine assigns a uniquely identifying number to each of its users. They retain information about users, their searches, location, and time spent online on the websites. A recent event created a controversy and questions of privacy invasion. On January 7, 2017, a Minnesota bank received a call from someone they thought was their customer, a man named Douglas, asking to wire a transfer of $28,500 from a line of credit to another bank. The bank relied on a faxed copy of his passport to verify the transaction. After the transaction was processed, the passport turned out to be fake. The Edina, Minnesota Police Department found the photo used on the fake passport when they did a Google image search. Edina Police Detective Lindman filed the search warrant request asking the court to authorize a search warrant for names, addresses, telephone numbers, date of birth, social security numbers, email addresses, payment information, account information, IP addresses, MAC addresses on anyone who searched variations of the victim's name, Douglas, over a 5-week period of time. On the same day, Hennepin County Judge Gary Larson signed and approved the warrant and requested Google to provide records of everyone in the city who searched 4 different variations of the victim's name between the 5-week period. It is highly possible that such a wide net could catch completely routine and non-criminal searches of the victim's name by neighbors, prospective employers, or business associates, or even friends. Some wonder if the warrant is constitutional, and if Google says yes to providing such information to the police, what will they use it for? Do they have the knowledge and technology to secure this information? What if the information is leaked in the investigation process, and most importantly, what would happen to those who Googled Douglas? Although Google declined to provide information to Edina, they revealed that there was an increasing number of data requests from governments and courts every year. In the first half of 2016, Google received more than 14,000 requests from US alone and provided information for 79% of them. HTML5 is the latest version of hypertext markup language. It is used for structuring and presenting content on the World Wide Web. The latest update has given websites multiple methods to store user information, such as location, locally on the client's device. Moreover, online tools and websites no longer need Flash plugins to access a computer's microphone or camera. Social networks like Facebook, Twitter, YouTube, and Snapchat play a major role in our daily lives, but they pose considerable risk to our privacy. Over the last 10 years, social networking sites have drastically changed policies regarding their use of user information. Instagram's terms of use state, Instagram does not claim ownership of any content that you post on or through the service. Instead, you hereby grant to Instagram a non-exclusive, fully paid, and royalty-free transferable, sub-licensable worldwide license to use the content that you post on or through the service. Most other social networking sites have similar user agreements. Facebook can collect your information like internet service provider, mobile provider, device location, your language and time zone, according to its data policy. These sites have gradually raised the level level of user information they share with third-party businesses. Although current law does limit privacy invasion through data sharing with third parties, there are 12 exceptions involved that allow the information to be shared. Most of the exceptions listed allow private companies to share user information with the authorities. Internet service providers, or ISPs, have entered the race for becoming major advertising businesses like Google. Your internet service provider like AT&T, T-Mobile, Verizon sell your information about web browsing history, app usage, mobile location data, etc. The Fourth Amendment of the United States Constitution protects individuals against unreasonable searches. However, these rights are not universal, as was evident in Katz v. United States, when the Supreme Court stated that the Fourth Amendment cannot be translated into a general constitutional right to privacy. It suggested what is now known as the third-party doctrine. The Fourth Amendment protects people, not places. What a person knowingly exposes to the public, even in his own home or office, is not a subject of Fourth Amendment protection. As a result, any information that we voluntarily provide to anybody is not expected to be private, and if the party in turn shares the information with the government, it is not considered a violation of the Fourth Amendment. Prior to 2013, legislators in the United States appeared to be more concerned about the data they could glean from social media than protecting the privacy of average citizens in the online world. Much of the rest of the industrialized world has a very different viewpoint about personal information than that which we experience in the United States. In Europe, Canada, and other countries across the world, protection of each citizen's private information is a human right enforced by government and private activists. In the United States, by contrast, only certain classes of information are protected under federal law: financial transactions, healthcare transactions, and information regarding children under the age of 13, while nearly all other data is considered to be fair game for any business or government agency that chooses to collect, store, and use the information. The Federal Trade Commission, or FTC, and state attorneys general have been the traditional protectors of online privacy for lightly regulated industries such as social media. But through much of the development of social media and socially oriented internet sites, these enforcement agencies have tended only to enforce the privacy policies that the site chooses to publicize. If a social media site had claimed not to gather certain information, but it indeed gathered that information, then the FTC would assert claims upon that site. However, if a social media site had a vague privacy policy that never clearly disclosed all the information it gathered, or if the site gathered and sold massive amounts of personal data from its users, and the site revealed its behavior in its privacy policy, then no enforcement action would be initiated because the site was not breaking any known laws. In other words, for most personal data about people, their activities, and their transactions, it seems that a social media site would not be regulated for use or abuse of this data, only for misrepresenting what data was collected and how such data was used. Deep intrusions of privacy may be allowed as long as the site does not directly misrepresent what it is doing. The Federal Communications Commission, or FCC, came up with an amendment to the Communications Act of 1934 in October 2016, which restricts internet service providers from tracking and selling consumer data without prior permission from the consumer. This law also allows consumers to opt in or opt out of data collection. This gives them significant power and upheld their privacy. But recently, on March 23, 2017, a bill passed by the U.S. Senate which aims to repeal the FCC's December ruling. If passed, such a ruling will allow internet service providers to exchange sensitive consumer information with customers such as Google and Facebook for monetary gains. This proposed law will make the exchange of consumer data completely legal and compromise the privacy of millions of people. This ruling also bars the FCC from any amendments to the same law, thus making this law untouchable. This move has been highly supported by the companies as it upholds their vested interests of making huge profits from the private consumer data. There are three major stakeholders involved who can take steps to safeguard user information against data abuse: the authorities, private companies, and users. It is clear that there is a lot lacking on the part of the government on this issue. Lobbying by private companies has clearly subdued the concerns raised by information privacy advocates. Although private companies have put self-governing policies in data usage, given the economical aspect, it is unlikely that they will put privacy concerns over financial gains. Users can maintain self-restrictions on the data they share over the internet, but given the current policies adopted by the companies, not using their services is really the only option that users have to safeguard their privacy. We are not ready for the future that is already being built. Our laws are not yet able to address these risks. Our technologies are insecure and leak data. In turn, we are not secure.